For years, the Commonwealth of Virginia has been ground zero for an escalating constitutional experiment. From the halls of Richmond, a relentless wave of legislative mandates has pushed the boundaries of the Second Amendment to their absolute breaking point. Law-abiding gun owners have watched, cornered, as disaster after disaster worked its way through the legislature. But right now, the legal landscape in America is undergoing a massive systemic shift. A high-stakes chess match is playing out between state lawmakers and the federal government for the first time. In recent history, the Department of Justice's Civil Rights Division is signaling an unprecedented move, a direct constitutional challenge against Virginia's new draconian gun restrictions. This isn't just local politics. This is a definitive legal battle that will set the precedent for every single firearm owner in the United States. And to understand how we got here, you have to look at the severe reality of what has just been passed. The legislative package recently pushed through the Virginia legislature isn't a collection of minor adjustments. It is a sweeping, fundamental overhaul designed to aggressively restrict the rights of lawful citizens. First, a comprehensive assault weapons ban aiming to completely prohibit the sale, purchase, and possession of the most popular rifles in America, most notably the AR-15 pattern rifle. Second, a ghost gun ban carrying extraordinary, disproportionate criminal penalties up to 10 years in federal prison for possessing firearms manufactured from completely legal individual components. Furthermore, concealed carry reciprocity has been effectively dismantled, leaving out-of-state travelers and daily commuters in a legal minefield. The moment they cross state lines, even the simplest act of self-defense has been penalized. Citizens now face a $500 fine if a handgun becomes momentarily visible, not for brandishing, not for threatening, but for a simple, accidental exposure of a lawful firearm. When governments pass laws this aggressive, they always claim it is done in the name of public safety. But the data coming out of Richmond tells a completely different story. At the exact same time the legislature was voting to turn ordinary gun owners into felons, they systematically removed mandatory minimum sentencing for actual violent criminals. A law-abiding citizen faces a decade behind bars for an unregistered component, while an individual convicted of violent acts against real people faces reduced consequences. To make matters more baffling, the same legislative calendar introduced measures to ease penalties for dangerous drivers on Virginia roads. This is not a coherent public safety strategy. It is an agenda that targets the easily tracked, law-abiding community while softening the blow for actual threats to society. The contrast is stark, intentional, and it strips away any pretense of genuine crime prevention. But Richmond may have miscalculated, because right across the Potomac, the federal infrastructure is quietly preparing to strike back. The Civil Rights Division of the Department of Justice holds the ultimate legal authority to challenge state laws that violate constitutional rights, and the leadership within this division isn't looking at this as a political debate. They are looking at it through the lens of pure constitutional law. They have already proven their willingness to act, filing federal lawsuits challenging semi-automatic rifle bans right next door in Washington, D.C. They have made their stance clear. Modern rifles are presumptively legal under the United States Constitution, and states that attempt to ban them are fundamentally wrong. The current silence from federal litigators is not a sign of hesitation or weakness. It is a tactical pause. Under federal litigation mechanics, a law cannot be challenged until it is officially active. For Virginia, that countdown ends around April 13th. The DOJ cannot act on a shadow. They must wait for the trap to spring, and when it does, they will be weaponizing the most powerful Supreme Court ruling of the modern era, a legal framework that completely changes how gun rights are defended in America. To understand why Virginia's new legislative package is sitting on a legal fault line, you have to understand the monumentally altered landscape of American constitutional law. For decades, lower courts across the United States used a highly subjective, two-step balancing test to evaluate gun control laws. If a state government claimed a restriction was necessary for public safety, judges would routinely look the other way, balancing away an individual right in favor of state power. But in 2022, the Supreme Court completely destroyed that framework with the landmark Brune decision. The Supreme Court established a strict, unyielding mandate. If a law restricts a firearm right, the government must prove that the regulation is consistent with the nation's historical tradition of firearm regulation. This means state attorneys cannot rely on modern statistics, political opinions, or emotional appeals. They must look back to the founding era, specifically 1791, and find a historical analog. And when you apply this historical tradition test to Virginia's new mandates, the state's legal defense begins to completely unravel. There is no founding-era tradition of banning the most commonly owned rifles in the country. In 1791, citizens were explicitly expected to own the standard frontline infantry weapons of the day by targeting the R-15 pattern rifle, a firearm owned by millions of law-abiding Americans for completely lawful purposes. Virginia is attempting to ban a class of arms that the Supreme Court has already deemed constitutionally protected under the common use doctrine. There is no 18th century analog for an assault weapons ban. The vulnerability extends even deeper into the ghost gun ban, imposing a severe 10-year prison sentence for assembling a firearm from individual unregulated components FLIs. Directly in the face of early American history, from the founding of the Republic, private gunsmithing and self-manufacturing were not only legal, they were a fundamental part of American self-reliance. The state of Virginia is preparing to walk into a federal courtroom with zero historical precedents to back up their claims. They are bringing a political knife to a Supreme Court gunfight. However, within the gun rights community, this impending legal battle has raised intense skepticism. Many ask a valid question: can a federal Department of Justice truly be relied upon to defend the Second Amendment? Critics point directly to the top of the department, highlighting inconsistent records from leadership. In states like Florida, high-ranking officials have previously supported red flag laws, restrictions on young adult firearm ownership, and open carry bans. These are real, documented compromises that cause legitimate concern for strict constitutionalists. But the strategy here doesn't rely on broad political promises. It relies on the specific structural mechanics of the DOJs Civil Rights Division. The litigation infrastructure tasked with fighting state overreach is driven by individuals who view the Brune framework not as a political debate, but as a mandatory legal instruction. Their past actions prove they are not waiting for permission. By already launching federal actions against restrictive regimes in Washington, D.C., the division has signaled that their roadmap for Virginia is already drawn. The entire situation now hinges on a critical legal timeline. Many citizens are demanding to know why federal lawsuits have not already been filed to stop Richmond in its tracks. The answer lies in the strict mechanics of federal litigation. Under Article 3 of the United States Constitution, federal courts can only hear active cases or controversies. A law cannot be challenged in court until it actually exists. As an enforceable mandate, as the legislative process concludes, the operative date for these restrictions to take effect moves toward April 13th. Filing a lawsuit on April 12th is a legal impossibility because no injury has occurred. The current silence from federal litigators is not a sign of hesitation or weakness. It is a tactical pause. The legal machinery is being quietly assembled behind closed doors, waiting for the exact moment the clock strikes 12 and the laws go live. When that date arrives, the Commonwealth will no longer be debating political talking points in Richmond. They will be forced to defend an indefensible legislative package against the full weight of the United States Constitution. What is happening inside Virginia is not happening in a vacuum. It is a calculated blueprint. Anti-gun legislative groups are watching Richmond closely, treating the state as a testing ground to see exactly how much pressure the American legal system can take before it cracks. If these laws stand past the April deadline without a swift federal takedown, this exact package will be copied, pasted, and introduced in dozens of other state capitals before the year ends. This is why the upcoming legal counter-strike matters to every single American citizen, regardless of which state you live in. Consider the immediate human cost of dismantling concealed carry. Reciprocity. For decades, the American travel and commerce systems have relied on the fact that constitutional rights do not vanish when you cross an invisible state line. Under the new Richmond framework, a truck driver from Tennessee, a commuter from West Virginia, or a family traveling down the East Coast can become an unwitting felon simply by taking the wrong exit. By gutting reciprocity, the state is actively turning law-abiding travelers into targets. It forces a free citizen to choose between their personal safety and a criminal record, completely disregarding the federal principles that bind the United States. Together, perhaps the most deceptive element of the new package is the $500 fine for a visible handgun. Lawmakers claim this is to prevent public panic, but the legal reality is far more predatory. The law does not require proof of criminal intent. It does not require brandishing, hostile behavior, or a threat of violence. If a legally permitted citizen reaches for a shelf at a grocery store, or if a gust of wind catches their jacket on a public sidewalk, exposing their firearm for a single second, they are instantly in violation. This is not crime prevention. This is a financial and legal trap designed to make the daily exercise of a constitutional right so stressful, expensive, and risky that ordinary citizens simply give up. To fully grasp the ideology behind these laws, you have to look at who they choose not to prosecute. A legislative body truly concerned with safety looks at violent metrics, homicide rates, armed robberies, and repeat offenders. Yet the exact same political coalition that voted to impose a crushing 10-year sentence on citizens assembling their own firearms voted to lower the stakes for individuals committing actual acts of violence. By removing mandatory minimums for violent crimes, the state has sent a crystal clear message. The weapon is the enemy, not the criminal. A career criminal facing fewer restrictions and a law-abiding citizen facing maximum penalties is the upside-down reality of modern state overreach. But the legal clock cannot be stopped, and April 13th is rushing closer. While state prosecutors prepare to enforce these new traps, federal litigators are finalizing their briefs. The groundwork laid out in the Washington, D.C. lawsuits has given the Civil Rights Division a flawless legal template. They don't need to invent a new strategy. They just need to deploy the one that is already winning. The state of Virginia believes they have passed a historic victory for gun control. In reality, they have walked directly into a trap of their own making, setting up a constitutional showdown that could permanently dismantle state-level gun bans across the entire nation. As the April 13th deadline approaches, the tension between state power and federal authority is reaching a boiling point. The state of Virginia is gambling its entire legislative agenda on the hope that the federal government will not step in. But history shows that when a state openly defies a Supreme Court mandate, the response is usually swift and devastating. The individuals pushing these laws are banking on the confusion of the public. They want people to believe that once a bill is signed, the fight is over. They want gun owners to panic, surrender their rights, and accept a new status quo. But they forgot one critical detail. The United States Constitution is the supreme law of the land, and no state legislature has the power to vote it away. If these laws take effect, the financial burden on regular citizens will be immense. To comply with the new assault weapons ban, thousands of peaceful gun owners will be forced to choose between registering their property like criminals, destroying their investments, or risking a felony conviction. This is a classic suppression tactic throughout history. When governments wanted to disarm a population but could not do it directly, they used economic warfare. They created high fees, expensive registration systems, and extreme penalties to price regular, working-class citizens out of their constitutional rights. The wealthy will always find ways to pay the fines and hire the lawyers. These laws are explicitly designed to disarm the average citizen who cannot afford a $500 penalty for an accidental slip of a jacket. To see the future of the Virginia lawsuit, we only have to look across the river to Washington, D.C. For years, D.C. maintained some of the strictest firearm bans in the developed world, completely ignoring the shifting tide of federal jurisprudence. When the Civil Rights Division finally stepped in, they did not just file a standard appeal. They launched a massive, comprehensive challenge that attacked the very foundation of the city's restrictions. The federal court's initial response sent shockwaves through anti-gun circles. The judges made it clear that under the new legal framework, the city's arguments were completely outdated. The D.C. case proved that the federal government is no longer playing defense. They are actively hunting down unconstitutional restrictions and tearing them down piece by piece. Virginia is next on the chopping block. The state government in Richmond thinks they have executed a flawless political victory. They celebrated on the House floor, took credit in front of the cameras, and promised their donors that Virginia would become a model for the rest of the nation. But legally, they have walked straight into an ambush by passing an all-encompassing package that violates the assault weapons protection, the ghost gun tradition, and the reciprocity framework all at once. They have given federal litigators multiple ways to strike them down. The Department of Justice does not need to win on every single point. They only need to win on one to break the entire package. When the clock strikes midnight on the effective date, the lawsuits will hit the courts, and the grand political experiment of Richmond will face the harsh reality of constitutional law. When the dust settles in the lower federal courts, this entire battle is heading straight back to where it started, the United States Supreme Court. The architects of Virginia's gun bans know they are going to lose the first round. Their strategy was never to win in the lower courts. Their strategy is to delay, appeal, and drag this litigation out for years, forcing citizens to live under unconstitutional restrictions while the lawyers argue. But the current Supreme Court has already shown that it has zero patience for states trying to play games with the Bill of Rights by establishing the historical tradition. The High Court sent a clear warning to every state capital in America. Richmond chose to ignore that warning, and now they are going to find out exactly what happens when you dare the Supreme Court to enforce its own rulings. The ultimate undoing of the Virginia package will be the sheer lack of legal substance behind it when the state's attorneys stand before a federal judge. They will be asked a single devastating question: where is your historical analog from 1791 that justifies banning the most popular rifle in America? They will have no answer. They will try to present modern crime statistics. They will try to show emotional statements from politicians. They will try to argue that the world has changed since the founding era. But under the post-Brune framework, the judge will have to reject every single one of those arguments. The law is absolute. If a restriction did not exist when the Second Amendment was written, it cannot legally exist today. Virginia's sweeping legislative package is built on a foundation of political theater, and it will collapse under the weight of pure constitutional history. This is the moment of truth for the Second Amendment. If the Department of Justice successfully executes this counter-strike, it will do far more than just save the gun owners of Virginia. It will create a definitive ironclad federal precedent that will permanently cripple gun control efforts in states like California, New York, Illinois, and New Jersey by forcing a direct confrontation over the AR-15 and self-manufactured firearms. Virginia has accidentally accelerated the timeline for total national gun rights protection. They wanted to build a wall against freedom, but they ended up building the very launch pad that will dismantle their agenda nationwide. The clock is ticking down to the April deadline. The laws are ready, the federal briefs are drafted, and the ultimate constitutional showdown is officially locked in. The battle lines are drawn, and the supreme law of the land is about to have the final word. The financial strategy embedded within the Richmond legislation extends far beyond simple penalties. It is a calculated effort to establish a de facto ban through economic attrition when a state implementation plan calls for the mandatory retrofitting, registration, or disposal of tens of thousands of lawfully acquired firearms. It creates a massive bureaucratic barrier. The hidden mechanism of this bill relies on the fact that compliance requires significant financial investment from the individual owner. This is a structural blueprint modeled after historic suppression tactics. By artificially raising the financial cost of legal ownership, the state effectively creates a two-tiered system where constitutional protections are accessible only to those who can afford specialized legal counsel and compliance fees. For the working-class citizen, the reality of a sudden $500 administrative fine for minor handling errors acts as an immediate deterrent, forcing a choice between financial stability and the exercise of a fundamental right. To understand why the impending federal litigation is heavily favored to dismantle these restrictions. 1. Must analyze the Supreme Court's established doctrine on firearms in common use. Under the foundational principles laid out prior to the recent state-level shifts, any weapon that is overwhelmingly chosen by law-abiding citizens for legitimate purposes receives immediate, robust protection. The AR-15 platform is not an outlier. It is the statistical baseline for modern rifle ownership in the United States. When the state attempts to classify the most popular rifle pattern in the country as a restricted weapon, it creates an immediate logical fallacy in federal court. A state cannot declare a firearm to be both unusually dangerous and simultaneously the most commonly owned rifle by millions of peaceful citizens. The common use metric is an absolute shield against categorical bans, and by explicitly targeting this segment of ownership, the Virginia legislature has handed federal litigators a mathematically indisputable case of constitutional overreach. The coordinated defense of this legislative package by state lawmakers reveals a broader national strategy. Virginia is being utilized as a crucial legal proving ground. If the state's defense can successfully drag out the litigation process through procedural delays, it provides a window of opportunity for neighboring jurisdictions to introduce identical packages. The objective is to create a contiguous geographic block of highly restrictive states along the eastern seaboard, effectively neutralizing interstate travel and carry rights through sheer regulatory volume. This strategy relies heavily on the assumption that federal courts move too slowly to protect citizens in real time, bypassing These laws simultaneously, anti-gun coalitions hope to overwhelm the litigation capacity of individual civil rights organizations. However, the involvement of a specialized federal division entirely resets this equation. The resources available for a coordinated multi-state counterstrike ensure that a victory against Richmond will instantly collapse the matching frameworks being drafted in surrounding state houses. The legislative focus on self-manufactured firearms, colloquially labeled as ghost guns, relies entirely on public unfamiliarity with American manufacturing history. The narrative pushed from Richmond suggests that private firearm construction is a modern loophole developed to evade background checks. In reality, the American tradition of individual fabrication predates the formation of the federal government itself, serving as a core component of early colonial self-defense and industrial innovation by criminalizing the possession of unserialized components. With a draconian 10-year federal prison sentence, the state is attempting to rewrite centuries of established legal tradition. There is no historical founding era precedent that restricts a free citizen from constructing a tool for their own lawful use. When federal judges apply the mandatory historical test to this specific mandate, the state will be entirely unable to produce a single historical analog from the late 18th century that penalized citizens for private craftsmanship. The systematic gutting of concealed carry reciprocity agreements marks a direct assault on the concept of national citizenship. Under the full faith and credit clauses of the United States framework, states are expected to maintain a level of mutual respect for legal permits and licenses by transforming a legal permit holder from a neighboring state into an immediate felon the moment they cross the border. Virginia is actively destabilizing the legal consistency required for interstate travel. This specific restriction creates an immediate national security and logistical crisis for commercial transport, daily commuters, and families traveling through the geographic bottleneck of the Mid-Atlantic region. The law intentionally treats a constitutional right as a localized privilege that evaporates based on geographic coordinates. This localized approach is exactly what the modern Supreme Court framework was designed to eliminate, ensuring that an individual's fundamental protections do not shift based on state boundaries. The enforcement mechanism for the new Virginia mandates relies on a massive expansion of the state's administrative apparatus. New regulatory bodies must be established to monitor compliance, track registrations, and process the influx of sudden violations. This administrative expansion occurs at the direct expense of existing law enforcement resources, diverting active personnel away from violent crime units to manage the paperwork of previously law-abiding citizens. This structural reallocation highlights the fundamental contradiction of the Richmond agenda. At a time when major metropolitan areas within the state are reporting significant challenges with violent crime retention and enforcement, state resources are being deliberately deployed to police the peaceful community. The long-term operational result of this policy is not a safer environment, but a highly litigious state bureaucracy that penalizes technical infractions while allowing actual criminal elements to operate with reduced institutional pressure. The moment the effective date passes and the first federal challenge is officially recorded, the immediate objective of the litigation will be a temporary restraining order and a subsequent preliminary injunction. To secure this, federal litigators must demonstrate a strong likelihood of success on the merits and a threat of irreparable harm to the citizens. Given the explicit conflict between the Virginia mandates and the Supreme Court's historical guidelines, the threshold for obtaining an injunction is exceptionally low. An immediate federal injunction will effectively freeze the enforcement of the assault weapons ban, the reciprocity restrictions, and the component penalties before a single citizen can be prosecuted. This initial ruling will leave the Richmond legislature with a completely hollow victory, forcing the state to spend millions of taxpayer dollars defending a frozen law that is structurally dead on arrival. The grand political showcase will quickly transform into a prolonged, costly judicial defeat on the national stage. The ultimate consequence of the Virginia legal battle will be the permanent closure of the legislative avenues used by anti-gun organizations for a generation. For decades, state-level bans were passed under the assumption that lower courts would always find a way to justify them under the guise of public safety balancing tests by forcing a direct showdown under the new strict historical guidelines. Virginia has inadvertently set the trap that will break this paradigm permanently. When the Supreme Court eventually affirms the invalidity of the Richmond package, that ruling will stand as an absolute permanent barrier against any future attempts to restrict standard modern firearms. Anywhere in the United States, the state of Virginia believed it was leading a revolution in gun control. Instead, it has provided the exact legal vehicle required to secure the Second Amendment for generations to reach. The battle lines are fully drawn, the litigation machinery is set, and the supreme law of the land is prepared to deliver a definitive, unalterable verdict. Subscribe.